By extension, access to justice, particularly to the poor and the vulnerable, who can now access justice via pro bono mediation services and the likes. To do justice to this very important topic, we have put together a high caliber number of speakers that are acknowledged in the mediation world internationally. We have Mary Walker as our keynote speaker. We have Professor Joy Ezilo as a speaker. We have Mr. Sean Hendricks as a speaker. We have Dr. Agada Elachi, Senior Advocate of Nigeria, as a speaker. I want to thank all our speakers for agreeing to share their wealth of knowledge with us today. I also want to thank all participants that have joined us today. If you were not here, we'll be speaking to the air. So thank you very much for joining. I'm Dr. Rosemary Chikwendo, Fellow of the Institute of Chartered Mediators and Conciliators of Nigeria. I'm moderating this session. With me is Dr. Adeyemi Agbelusi, another Fellow of the Institute of Chartered Mediators and Conciliators of Nigeria. At this point, I would like to thank you, Dr. Agbelusi. At this point, I would like to invite the host of the session, our president, Mr. Godwin Omoaka, Senior Advocate of Nigeria, to give his opening remarks. Mr. President, please.
Thank you, Rosemary, for that brief introduction. I'm trying to get my video on, but it couldn't start. It says it's been disabled by the administrator. So perhaps those behind the scenes can help me.
Yeah, can put it on now.
Okay, thank you.
Can put it on now.
Okay. Thank you very much. I'm Rev. Dr. Agbelusi. Good afternoon, good evening, good morning, depending on where you are, distinguished guests and participants. I welcome you to our webinar on strengthening the justice sector in Africa, ensuring access to justice via mediation. The Institute of Chartered Mediators and Conciliators is proud to host this event in collaboration with the United Nations NGO W68 Parallel Event. As the landscape of ADR continually evolves globally, mediation has emerged as a powerful tool for achieving justice. As a dispute resolution method, mediation empowers disputing parties to find solutions that are tailored to their needs, of course, with the help of the third party neutral, who is called the mediator. Across Africa, even from historical times, there has been a rich tradition of informal dispute resolution mechanisms, including negotiation, mediation, and traditional forms of arbitration, which is generally known as customary arbitration. However, formal mediation is gaining significant traction within our justice delivery system. While concerns exist regarding adherence to mediation agreements and enforcement of a mediation settlement agreement, at least at the municipal level, because we know at the international level, some of those concerns have been addressed by the Singapore Convention. This webinar delves deeper. It will explore, amongst others, how to leverage mediation to strengthen the African justice system. After all, without robust access to justice, including effective mediation, sustainable development, and trade across the continent will be hindered. So I want to profusely thank all the speakers for taking our time to participate in this process. And I encourage each and every one of us to participate actively. Please ask questions, engage in conversations, and challenge some of the ideas that have been presented. My special appreciation goes to our esteemed keynote speaker, Mary Walker. Mary Walker a member of the IBA Committee Advisory Board and co-chair of the International ADR Committee. Thank you very much and good afternoon.
Thank you very much. It's a great pleasure to be with you today. In Australia, it is our custom to recognise our First Nations peoples. So to begin, I acknowledge the traditional owners of the lands from which I speak to you today, the Gadigal people of the Eora Nation, and their elders past, present and emerging. As you know, the topic for today is strengthening the justice sector in Africa, ensuring access to justice via mediation. Access to justice can be understood as access to dispute resolution mechanisms for all people, regardless of their means, background, or capabilities. The NYU Centre on International Cooperation prepared a report from a task force on justice, noting that to achieve the goal of providing access to justice for all, we must place justice at the heart of sustainable development, put people at the centre of justice systems, and move from justice for the few to justice for all. Today, I will talk about pathways to access to justice, perceptions of fairness and justice, adaptation of consensual processes such as mediation, polycentric value-laden disputes and cultural differences, and how this fits into this idea of access to justice. Currently, the justice systems around the world are struggling to help people effectively. Cost and delay has not been overcome. Access to justice is still a challenge. Vulnerable people are disadvantaged. Power imbalances have not been cured. Differences between dominant and minority sections of society and power imbalances are still a feature in many jurisdictions. Cultural demographics can still be also a feature of those who can afford access to justice systems and those who cannot. And we are in an era when legal aid resources are being reduced or limited across jurisdictions. The world faces a global justice gap, and the poor and vulnerable are the most affected. There is a PricewaterhouseCoopers report on the economic value of legal aid, and it noted that around 5.1 billion people today, that is 2/3 of the world's population, lack meaningful access to justice. That lack of access to justice traps people in vicious cycles of poverty, inequality, and marginalisation. The burden of the justice gap falls disproportionately on the most vulnerable, including women, children, and minorities, the elderly, and people with disabilities. Lack of access to justice also increases the risk of conflict and violence within a society, and thus the safety and prosperity of those most vulnerable is key. So how does mediation help? Mediation puts people at the centre of the process. People have a voice. ADR is not new, and mediation is not new. Negotiated settlements, mediation, and arbitration for centuries have been used to resolve disputes. Our previous Chief Justice of New South Wales, who just retired, the Honourable Tom Bathurst of the Supreme Court, has stated that certainly in our jurisdiction in Australia, our system of law recognises that the administration of justice does not prescribe an inflexible or invariable standard of justice, so long as a minimum standard of procedural fairness is observed in the process adopted by the parties. In Australia, we have a common law system, and procedural fairness and the rule of law are the basic tenets of our justice system. Just going back to the PricewaterhouseCoopers report, it also notes that if we accept that legally enforceable rights and duties underpin a democratic society, access to justice is essential to make these rights and duties real. In Australia, the discourse relating to the development and institutionalisation of mediation commenced with a focus on the early resolution of disputes to reduce the cost of litigation and delay in the finalisation of disputes, which was later grounded in this context of access to justice. So the practicalities of cost and delay really was the moving force, I suppose, in looking at access to justice. There was a Research Centre study 7 years after the introduction of mediation in the first settlement week, which I'll talk about in due course, by the Supreme Court. The study showed that there were significant differences with plaintiffs' perceptions across dispute resolution procedures. 255 plaintiffs in our district court, which is a county court, were studied in respect of their perceptions of justice. And it was really interesting because plaintiffs saw that they perceived fairness and satisfaction with the legal system, which was affected by the variety of procedures that were adopted. And it was there were pretrial conferences, mediations, arbitrations, and litigation. And the proportion of pretrial conference and mediation plaintiffs who were satisfied with the legal system that handled their claim was 81% and 80%, respectively. And it was much greater than the proportion of satisfaction of the legal system and the perceived satisfaction of the legal system in arbitration and trial. In arbitration, 54% were satisfied and 50% in litigation. So what we found is that also reflected very much the idea of perceptions of fairness. That informed us greatly at the time about how one should engage with the different processes. So how is mediation helpful in providing access to justice? It helps remove the barriers of impediments to access to justice, provides access to remedies other than money, helps in retaining relationships, reduces cost and delay. Mediations in my jurisdictions can be set down for a day or half a day, but in the first settlement week, which occurred in 1990, they were scheduled for 4 hours each. Mediation takes into account cultural sensitivities, and it can include all stakeholders. So if you don't have locus standi in court, but this is an issue that perhaps affects the community or otherwise, mediation can assist in giving everyone a voice and an opportunity to create and factor in issues so that there can be sustainable outcomes as far as resolution. So managing the future, moving parties from the past and sunk costs, focusing on the present and what will happen in the future is a key element in mediation. People come to the table with loss and grief because of past losses, but mediation focuses them on the present to create and factor in what can be done for the future for them, which is created in resolution, a settlement which often is enforceable. So what happened in Australia? It has been 30 years since our first settlement week was held in the Supreme Court with the New South Wales Law Society. And Australia was then at the forefront of global developments in ADR in the civil and commercial jurisdictions. What is often neglected in our discourse and narrative about ADR is that mediation really commenced in the industrial and employment fields, in family law and community justice centres, and in tribunals. It then proceeded to develop across the larger monetary matters of commercial, insolvency, intellectual property, class actions, and so forth. And what we have in Australia is, since 2005, is an embedded referral mechanism of a mandatory nature in the majority of our jurisdictions. That's both state, territories, and also federally. When I reviewed the statistics found in annual reports in courts and tribunals and those collated by the New South Wales Bar Association, I had to go back to 2018 to get a correlation across all of these institutions. And during 2018, the Supreme Court Registry recorded a total number of 1,169 referrals to mediation, court annexed or private, which was a 24% increase from the 2017 total of 943 referrals. We're now in 2024, and that is also increased. It is possible that the total number of referrals, though, doesn't include private referrals to mediation because they're not caught in the statistical basis of how one looks at this in the annual reports. The bar statistics in 2018 noted that 1,000 out of 1,518 respondents, 65.9% stated that they had appeared in mediation or arbitration during the preceding year. In our jurisdiction, the majority of matters go to ADR now in the form of mediation, not so much arbitration. And in 2018, 13% of respondents indicated that they were accredited as ADR practitioners. That has increased also significantly. The idea that there is an alarming drop in revenue, another, I suppose, meaning of ADR, which is bandied around in different jurisdictions, has not come to fruition in my jurisdiction. We are now in a situation, as I indicated, that all civil matters are referred to mediation. There's more work than ever before. But interestingly, arbitration and expert determination are processes similar to our traditional competency skills embedded in litigation. Our transition to practice in determinative ADR methods was not foreign to our basic legal training. But here lies the difficulty. The theory and practice of mediation was an additional learning, not necessarily separate from legal training. And now in our university legal training, ADR is a mandatory component in what we call the priestly 11 subjects. But assuming that most lawyers will be mediating matters which have their genesis as legal disputes and as court referred, the challenge is how to employ these additional skills and frameworks without resorting to old habits and minimizing the process. So what we have is a situation in the old days where people might negotiate settlements, but they would end up in court. We now have a variety of dispute resolution mechanisms, as you would have. But as I said, the majority of matters go to mediation. And negotiating settlements is a commonplace event in practicing as a lawyer in our jurisdiction. And negotiation is the kernel of the majority of consensual processes, including mediation. So our focus in the common law jurisdiction has really changed. And I heard a speech by our Chief Judge in the Land and Environment Court, and we have multi-door courts as envisaged by Frank Sander at Harvard. And particularly in some jurisdictions, you will have 90% of matters that will go to an ADR process rather to traditional court litigation. And I think if you come from a common law system, the reports of Lord Wolfe and Lord Jackson in the United Kingdom highlighted the benefits of court initiatives and negotiation and mediation. As I said, none of this is new. It merely exemplifies the need for practitioners to be knowledgeable in all of these skills, particularly negotiation and mediation. So we now have regulations, rules and guidelines in mediation. The Law Council formulated an ADR policy in 1989 and promulgated a trilogy of mediation ethical guidelines for mediators, lawyers and parties. And also we have had our Chief Justice, who recently retired, put forward a paper, Off with a Wig, Issues that Arise for Advocates When Switching from the Courtroom to the Negotiating Table. It is such commonplace that the idea that you have to wear two hats, a wig, if you will, as well as taking it off and being at the negotiating table, is a normality. But what we had to do was to talk about the obligations of lawyers as court officers in that movement. And so being a court officer comes to the table in mediation, and the ethical obligations also come to the table, particularly in all matters for lawyers, but particularly in court-ordered mediations, which, as I indicated before, is a norm for us. So let's talk about pilot projects and pro bono mediation services. How did we start? In 1990, our first settlement week held by the Supreme Court was highly successful, with, from memory, I think above 60% success rate on the day and a higher rate within 2 months of the mediation session. Success was defined as of the mediation broadly, but also in these statistics, it meant a complete resolution of the dispute within 2 months of the mediation session. They were held for 4 hours. The costs were divided equally between the parties, and there was an hourly rate paid to the mediator at that time. This went on for several years, and different government programs were also commenced, similarly with hourly rates. After that, mediators and parties agree in the private arena on those rates, but in government schemes, it is something which is determined by the scheme administrators. Pro bono schemes, however, were also set up to assist those in need and provided a means of mediators gaining experience. In Australia, we had many mediators trained, but they could not easily gain experience. And this initiative ought not be underestimated. It created a win-win, benefits for each group. So we had those who required and needed assistance, as well as those who needed to gain experience. And that dovetailed in and continues to do so. The challenge for 2024 in the near horizon in mediation, I think, is a focus on ethical behaviour and best practice of lawyers. And lawyers can be the preeminent practitioners in this area. Lawyers have the ability to be leaders in mediation. Utilising consensual processes, particularly mediation, can only strengthen the justice sector in Africa and everywhere, and create pathways for access to justice that are responsive to the need for enhancing perceptions of fairness and justice and access to justice, to be culturally sensitive, and to assist in dealing with complex, multifaceted, value-laden disputes that we are confronting in the 21st century. In Sydney today, I spoke at the inaugural Australian Disputes Centre conference on what these disputes will be like in the 21st century. Environmental disputes, human rights disputes, the need for those in first world countries and those engaged in social media to have a voice. And if there is a do-nothing approach, we have social disruption. So how do we manage these? And I indicated to everybody that my view is that the consensual processes such as mediation, facilitation, and so forth are the means of creating an ability to design processes for the betterment of the public good, for the public interest, and for the many. And I'll leave it at that and open for questions. Thank you. Sorry, Rosemary, I can't hear you.
Muted. Thank you very much, Mary. And in the quintessential Mary mode, unbundling what you have just said in 2 minutes is a huge challenge. But I must start by noting that you said that 1.5 million people lack access to justice. And that is, I think it's in Australia alone, I know billions lack access to justice world over. And they are particularly the poor and the vulnerable. You also highlighted the place of mediation, how mediation has increased access to justice for the poor and the vulnerable. You highlighted the effect of mediation in strengthening the justice sector. You also mentioned that mediation, you actually discussed the core benefits of mediation. And at the top of it is that mediation is people-centered. It gives them the opportunity to discuss their matter by themselves, and it moves them from being in the past to being in the present, thereby being able to address the issue at hand. You also said that lawyers are important in the practice of mediation. It is the same problem all over the world, particularly in our climate. We need the buy-in of lawyers to be able to use mediation to resolve disputes effectively. So this stands as a call to lawyers that have joined us today. We'll continue advocating that you acquire the skills of mediation. That way you'll be able to help your clients more effectively. Thank you very much, Mary, for that explosive presentation. And I plead that you hang on so that you take the answers at the end of the session. But if it's not possible for you, because I know it's like 2 a.m. in Australia, if it's not possible for you, indicate then we can take your questions now before we move on, with the permission of Sean, of course. Thank you very much.
I'm happy to hold on.
Thank you. Thank you very much. Dr. Agbelusi, over to you.
Thank you very much. Our next speaker is going to be Sean, and we're speaking to us for 15 minutes on his own viewpoint and his own experience. He's a co-chair of Mediation Committee of the IBA, and he has quite a large experience to share with us. So I invite you, Sean, to please take the floor and do justice to your topic.
Thank you, Dr. Agbelusi. Thank you, Rosemary, for your invitation, and also to Dr. Godwin. It's an honor for me to be here to share, as indicated, some of my experiences. I apologize if some of what I say may have been maybe a repetition of some of the points Mary brought up. Obviously, we're here discussing a common theme.
Sorry, Sean, your camera is off.
Sorry about that. Am I there? Yes. Okay. Hi, everybody. Okay. So firstly, hasn't been indicated yet, but I am from Jamaica. I was born in Jamaica. My mother was from Germany. My dad was from Jamaica. So the commonalities between Mary's experience and mine relate to the fact that we're both from originally common law jurisdictions. Jamaica was originally a colony until 1962. So we still have a lot of the former civil procedure and basic legal framework that existed before then. In respect of mediation, we formally got mediation on the books. In about 2002, mediation was included in our civil procedure rules. As in Australia, most civil matters are in fact referred for mediation for the parties to attempt to settle out of court. The intention behind that was to assist with what we consider to be a very large backlog of cases, and not enough resources, not enough judges, not enough time to deal with those cases. So again, significantly adversely impacting access to justice for those already caught up in the system and those who had matters that they wanted to refer to the system. Yeah. So mediation was seen back then in 2002 as a very promising avenue to pursue in that regard. So as I said, it's been formalized since 2002. I myself, when that opportunity came about, became an accredited mediator in 2002 on the Supreme Court's roster. The Supreme Court has an appointed referral body, which is called the Dispute Resolution Foundation, which has been reasonably successful. I think the last success rate or rate I heard of was around between the high 70s, mid 80s for mediation. Obviously, there's still some of the older entrenched, views exist between the advocates that if you have a strong case, then why would you want to settle? It shows weakness, et cetera, et cetera. But there's no disputing the fact that it has and can continue to assist in reducing backlogs, in expediting people's access to necessary, justice and so forth. Yeah. My approach is in this presentation. What I'm going to try and do is approach the access to justice issue discussion from a more practical viewpoint. Yeah. I think we need to certainly appreciate the basics of where we're all trying to get to with this in order to understand and to move forward. Yeah. I view access to justice as being about stories which may involve all of us, whether as individuals, collectives, also entities, from time to time, regardless of the respective circumstances that we're in. Yeah, we've all been in situations where we've needed some kind of redress, not some kind of way to rebalance what we perceive or think to be an injustice that was done to us. Yeah, so I think stories or examples of that put us in a position where we can approach the whole question as to how do we increase and improve access to justice for others in a more practical light. So imagine the following simple scenario. Briefly, we have siblings, a sister and a brother in their early 20s. A dispute arises over access to an outdoor communal water supply, a standpipe, after the in-house supply was off for whatever reason. The sister was the first using the outdoor supply. The brother arrived after, rushing to get the water he needed and get on his way. An argument ensued, and the sister was very forcefully knocked out of the way, and the brother proceeded to use the water he needed. The sister went away, and she returned a few moments after in a rage with a machete, and she started feverishly slapping her brother with the flat end, the flat side of the machete, not the sharp edge, which, although not a chopping impact, can still and did result in bleeding and heavy bruising. This was now a full-blown family communal conflict. The police were called by other family members. The brother claimed he was attacked with a dangerous weapon, and the sister that she was first violently assaulted. So we have a scenario, a real-life scenario. We can all speculate on the various ways in which the above dispute could possibly have progressed, as well as the interim stages involved and the ultimate ending. Whatever the outcome, however, the example highlights the significance of the condition, the availability, and the response of the justice system in place. Yeah. So those three things to me are important: the condition, the availability, and the response of the justice system. Access to justice, simply put, refers to the ability of individuals and communities to effectively and comprehensively have access to and to utilize, equally as all others might when necessary, the intended benefits of the legal system. We and all others require from time to time remedies for our legal issues. We require and are supposed to enjoy protection for our various rights, and equally important, we require fair treatment under the law, equal to that of all others. Constitutional provisions in various jurisdictions, including Jamaica, for example, which has a written constitution, guarantee the right to equality before the law, guarantee that no person shall be deprived of their liberty except on reasonable grounds and in accordance with fair procedures, and guarantee that persons charged shall be afforded a fair hearing within a reasonable time by an independent and impartial court established by law. Despite the above guarantees, however, for many persons, there remain significant obstacles to accessing the required aspects of the justice system. These obstacles may include financial constraints, with appropriate remedial processes and representation being unaffordable for many. Other obstacles may be geographical and/or physical obstacles, where representation and courts may be too remote and or costly to travel to. There is also legal and procedural complexity, as well as language and culture, which can result in the justice system having a completely unfamiliar and discomforting, if not intimidating, feel for many users. There are also systemic barriers and disparities within the legal system, just as there are underfunded systems, all of which may render any access to justice highly frustrating and stressful, if not impossible for many. An example of my own, which I can share, of the stress which a party may associate with a complex and unfamiliar forum and process is when I conducted a cross-examination in the local dialect here, referred to as patois, because I noted that the witness was very uncomfortable answering in English. He in fact expressed genuine gratitude on being able to communicate comfortably, feeling less intimidated by and being able to better participate in the process, which also facilitated a more efficient process. In fact, the cross-examination became so comfortable that we were smiling, if not laughing at points, and even had the judge laughing on a couple of occasions. So the ability to engage properly, to communicate properly, was certainly a significant bonus for that particular witness. There are various suggestions regarding ways in which access to justice may be improved. Some of the more widely discussed being public and private sector awareness of the challenges experienced, of people's fundamental rights and potential benefits of better access to justice. Also, the availability of a properly funded justice and legal aid system, as well as pro bono representation and provision of legal services. There's also more extensive use of technology, such as video hearings, which we can, pursue. And also greater use of the various ADR options, including, as mentioned by Mary earlier, which are all available for resolving disputes. This particular presentation is focusing basically on pro bono work and mediation. So I'm going to now basically refer to those two. Pro bono work, or providing legal services for the public benefit, plays a crucial role in improving access to justice in many ways, in particular for marginalized or underserved populations who may otherwise be unable to afford legal representation. It helps to ensure that everyone, regardless of their financial circumstances, has equal and fair access to the legal system and can seek redress for their legal issues. Many legal organizations and bar associations encourage and support pro bono efforts through volunteer programs, training, and recognition for attorneys who engage in this type of service. It also helps to supplement the resources, scarce resources in many cases, and the reach of legal aid organizations. Lawyers also are able to provide free or reduced rate legal services to individuals who may not qualify for traditional legal aid, but still cannot afford the level and expertise of private representation required by parties. Pro bono work also includes advocacy for systemic change. Volunteer lawyers often engage in strategic or impact litigation and policy advocacy to impact societal change. This goes towards addressing systemic injustices and improves access to justice for broader communities. Pro bono work also provides lawyers, especially those just starting out, with opportunities for professional development and community engagement. It's worth mentioning that pro bono legal representation is also provided for in very busy commercial settings. One example is the financial free zone known as the DIFC in the United Arab Emirates, the Dubai International Financial Center. The DIFC is an independent legal jurisdiction with its own laws, courts, judges, and procedural rules. The DIFC court system has its own pro bono program in which lawyers with rights of audience in the DIFC courts are able to volunteer their services to parties such as employees or tenants with issues in that jurisdiction. This facility provides a much needed restraint against any excessive imbalance in power that employees and tenants may face against what are commonly in that particular offshore jurisdiction extremely wealthy entities, as employers and landlords. So it also has its place there, Clearly, the significance of accessible, affordable, appropriate legal representation is not to be underestimated, and the availability of pro bono representation goes a long way towards providing all parties an opportunity to, as it were, stand their ground. Mediation is another instrument of justice, which we're focused on today, being a more affordable dispute resolution option than both litigation and, for example, arbitration. It helps to expand access to justice by helping to reduce, in one instance, financial barriers. Mediation is also more flexible, informal, and less complex as a process when compared to litigation and arbitration. That benefits those who may feel intimidated by the adversarial methods of dispute resolution and who prefer a less daunting and/or less adversarial setting. Mediation also facilitates active participation and shifts the balance of control to the parties in resolving their disputes. Having control of the outcome is arguably more empowering and satisfying for all types of parties, including just the marginalized, indigent, or vulnerable individuals who may feel overwhelmed by the many obstacles already mentioned, which they may face in a legal system. Exactly because of the collaboration towards a joint settlement of the dispute, mediation can be seen as objectively fair, and it can preserve or repair the relationship between disputing parties due to a greater inclination or level of comfort for parties participating in mediation, as opposed to using a process which solely determines legal rights and obligations. So mediation provides a genuine opportunity through such party autonomy, not merely to have access to justice, but arguably access to the purest form of justice. And these are my words, these are my thoughts. Justice which is tailor-made for the parties by the parties themselves. Customized solutions can often address underlying issues or concerns more effectively than standard legal remedies, which in turn contributes to sustainable resolution and access to justice. More importantly, can any other option available provide parties with more potential to be comfortable with the process, with the outcome, and with each other, including going forward? I would argue not. But again, those are my thoughts. Looking forward, going into the future, we have to consider the challenges, persistent and new, which are obstructing access to justice. And we must be bold with strategies for removing those persistent barriers so that access may be enhanced for more and more people. We need to continue striving to secure the commitment and action of both the public and the private sector to the provision of an accessible and fair system of justice. Appropriate action and results can only come from a comprehensive understanding and assessment of the circumstances being faced, which in turn requires a genuinely willing, focused, transparent, and flexible engagement between all stakeholders. Simply put, we need to feel what those attempting to access justice are themselves experiencing, and we need to make a genuine effort to improve that experience. Innovation in the provision of legal services and dispute resolution, as well as our individual approach to private practice, can definitely benefit those needing better access to justice. Those in private practice can play an important role in facilitating such access. Just as pro bono lawyers can supplement the benefits provided by legal aid systems, other practitioners can supplement both by offering, if not a certain amount of pro bono services in every accounting period, then creative billing solutions to accommodate parties in need of representation. Such creative billing solutions may take the form of fixed or capped fees where possible, thereby assisting parties with more affordable access to the necessary legal representation. Additionally, more practitioners may arguably be inclined to provide free or cheaper services if there were also tax incentives provided by the authorities for doing so, thereby also enhancing access to justice for those in need. We also have to accommodate, if not embrace, technology and the potential inherent for the provision of more efficient, sustainable, and cost-effective justice. Just as online hearings have significantly assisted in mitigating the issues of distance from and the cost of getting to justice, AI, or artificial intelligence, may very soon be providing basic, if not conclusive, guidance on how to resolve our legal concerns. I'll now go back to the brief story I mentioned above and the conclusion of that. As first-time offenders, the police and pro bono representation engaged in discussions and decided to send the siblings and their dispute for an attempt at mediation. The dispute was the subject of a mediation I handled in about 2002 to 2003. After a cold and slow start, siblings engaged in the session. Then they engaged with each other and eventually withdrew their respective complaints against each other. Charges were not pursued. The dispute was settled and the journey to resuming normal family life without further legal consequences began. In the above example, we can clearly see the importance of sensitizing all players with any connection to the justice system. They should acutely appreciate the impact that their effort to fully understand circumstances has, which the police in this situation apparently did, and also to appropriately measure and target their respective approaches to justice, disputes, and the rights of people, all of which can have a profound impact on the parties in the end. With awareness and adequately funded legal aid systems and pro bono assistance topped off by affordable mediation, Those are the components that give both of these parties a chance they may never have had otherwise. In closing, I'd also mention that there are a number of efforts at improving international access to justice, which is even more complex. It involves collaboration between governments, international organizations, civil society groups, and legal professionals. Some key initiatives are the International Bar Association. The IBA has an access to justice and legal aid committee itself. Mary herself was a panelist on a very interesting discussion they presented last year. There's also the United Nations Sustainable Development Goals Initiative, the UNDP, United Nations Development Program, the World Bank Group, and there are a number of others, yeah? So basically, it goes without saying that there's a lot of work left to be done. There is an appreciation globally that there is work to be done. As Mary indicated, there are many people who are marginalized. I think the number she indicated was 2/3 of the population basically don't have appropriate access to justice. And we need to focus on the ways and be creative and be bold, as I indicated earlier, in approaching solutions, in suggesting solutions, in coming together, even as practitioners, because as soon as we're approached by clients, we know that the clients need assistance. We know that. So it's a balance between our interests and their interests. Yeah. So we can intervene. We are on the front line and we can start the battle. We can start the efforts right there. As I said, including with just negotiating fees, if any fees at all, depending on the circumstances. Thank you very much.
Thank you very much, Sean. You've shed a lot of light on the role of pro bono access to justice, especially in the criminal sector, restorative justice, and in dealing with petty crimes. And I'm sure this is something that we will learn a lot from and reflect about. It's not just an African problem, it's a worldwide problem. And I'm sure that we will get more questions from those interventions. I'll call on, thank you very much for the presentation. I'll call on Rosemary now. I don't know if Professor Izero is here or if Dr. Gara is taking the turn.
Yeah, I am. Okay. Yes, I'm on.
Prof.
Yes.
Thank you. Thank you for jumping in. Professor Izero is a professor of law, a senior advocate of Nigeria, a recipient of the National Award of the Order of the Niger. I hope I'm right. Thank you for joining us. I know you are in a function, so take it from there.
Yeah. Thank you so much. Thank you. I'm indeed honored to be part of this program of IBA. Rosemary, thank you so much for the invitation. And I listened to the last two speakers. I came in when the one before the last was speaking from Australia. I think it's Mary. So and I think it's been really going on well. A very interesting topic always, and reminds us about the ultimate goal of law. And I think the ultimate goal of law, we need to be reminded. We do this as law student, jurisprudence class, and all of that. Is to produce justice, because I think this is sometimes lost on us, even as lawyers and mediators or what have you. The ultimate goal of law in any given society is to produce justice. But you see that because of even unequal or the inequalities that persist in society, it makes it indeed a Herculean task to really produce that type of justice. We've had, and I'm sure it's been mentioned about the unmet justice needs. Unmet justice needs, when we're talking about, is billions of people, and up to 5.1 billion people today, 2/3 of the world, lack meaningful access to justice. And given the number of cases I've been personally involved as a lawyer, as a senior advocate of Nigeria, I know that this is not just numbers. I know this is a reality, because if in the last 26 years of my involvement in pro bono work through Women's Aid Collective, we provided over 62,000 free legal aid to women, to a particular category, women and children in need of justice. Then you know that really this is a big issue, and access to justice is part and parcel of inclusive development, and that we know. And I think what we are discussing today is strengthening that justice sector and ensuring access to justice for millions, in need of that in Africa, and through mediation. And why mediation? I'm sure, even looking at the concept notes for this very parallel event, one will understand really when you look at the objectives about the importance, reinforcing the importance of pro bono work, sharing experiences and insight on the impact of mediation as a tool for strengthening the justice sector, and being involved and mediating, especially in human rights cases, in women's rights cases. I know that this is really very important. Beyond the unmet justice need, we all understand what mediation involves, and all the stages and who a mediator is, and the fact that a mediator, as a neutral person that waits into a dispute to assist people who are involved, the disputants in the case, to negotiate acceptable resolution. So it is really in a most friendly manner, because we know what the court system looks at, especially as lawyers, and we know also the factors that impede a person's access to justice in several jurisdictions, especially even within the sub-Saharan Africa. The courts are very user-friendly. Their proceedings, formalities, language, technicalities, it even scares not just litigants. Even some lawyers never get used to it, and so wouldn't want to practice or appear in court. So in addition, you have also particular classes of people affected by prevailing social norms, religious, customary law. They impact on status of women. There are even courts that will not allow physical access, and I mean physical access, to women, even to the court, even to be able, even in Sharia courts, some of them women can't even appear, even as lawyers, not to talk of even litigants appearing in some of these courts. So cultural justifications, cultural relativism, use of stereotypes, judicial stereotype, customs, religious norms, denying in particular women and girls, and even the poor, access to education and information that are all potential barriers to access to justice. So the injustices in substantive and procedural laws, are huge, and also makes it not only imperative, but also the need to use mediation as a tool to kind of bypass all of this. So in mediation, it's really important for lawyers to take on pro bono, but we see that in some jurisdictions, they just do it either to get a senior advocate equivalent of Queen's Counsel or King's Counsel, or whatever. And then some just get what is required, and that's it. And some also, especially with the prevailing economic climate, some also are not willing because it costs money. But again, we know as lawyers, the primary objective is not for us to make money, but also to ensure that the ultimate goal of law, which is justice, is achieved. And that's why we are ministers in the temple of that justice. But then for mediators, it's important to really understand the parties, the meeting, the issues about meeting of parties, venue. If I have time, I'll give an example where each of these matters, role of mediators, what issues can we look at? Some will think when you think of mediation, they just think of contractual. They don't, some also say, oh, not family matter. Oh, okay, family matter can be involved. Oh, maybe not. It can exclude personal injury or some tortious wrongs. I think mediation can be used in not just contractual issues, human rights, women's rights, personal injury, family law, and it's actually very important. I've been involved in a lot in intrafamiliar conflict and using mediation as a tool. And it becomes important because if you look at disadvantages of formal litigation, And then some of the, you find that because it's a very friendly kind of environment, then, and if you settle through mediation, it will now take away the issue of acrimonious, inimical, what can affect relationship at the end. It can become very inimical following litigation. But if people are settled and accept and then have memorandum of understanding and agreement, then at the end of the day, they agree to be bound by it. And if they are bound by it, then they amicably accept it. And this is what we do every day. For example, if I use, Wakol, I guess there was a time IBA, when they supported us, and they were just not only thrilled, but the number of cases. And I said, this could be sad. At the same time, yes, we're happy we address it, but it just tells us that so many people are in need of this. And for those who are worried that this may mean diversion and lawyers not getting their money, no. There are poor people who ordinarily will not be able to access that justice. And if in family relationship, what is the ultimate goal again? You don't want, even if the marriage has to break down, but you think of the best interest of the children, and you want a situation settlement that will enable that best interest of a child to be taken into account, not the one. There was a divorce matter that I had to mediate. It was so acrimonious. They were feeding the children with all sorts of things. But when we had to bring them together after talking to each individual party, just think of your children, think of these children. They didn't ask if they had to if they had to be asked about their choice. They wouldn't want the parents to divorce. And now people are involved in this. You're adults, they may not even understand your issues. Just leave that your issue for once and let the overriding interest for this settlement be about your children. And then eventually, because maybe if it was decided in customary courts, they can award custody without even thinking. To usually they award to the man who they say paid the bride price, and that means that the woman will lose her completely, and then she may not even be granted access, because once the man takes, he can just take it and give to another member of the family who is living far away, and they will mischievously do that so that the woman may not even have access. But with mediation, we said, okay, these children at this age, can they stay with their parents? Then the man also, you have access. You, as a father, you have access to them. And when you settle all of this and sort it out, nobody will be going to school to abduct children. Nobody will get children involved in adult matter and affect them that what will have permanent trauma and psychological effect, on the children. So it really should be advocated, because especially in divorce cases, the kind of acrimony that goes into it. We've seen cases where, for example, there was one of the cases we handled early this year. The couple came back home, from Christmas to Nigeria, but they didn't know what the man had in mind. So once they returned, he took all of their passports and left back to Europe. And now I said, okay. And then they didn't, by the time they realized it, so it's just like, okay, you guys just stay there. Have taken away their travel papers and stuff like that. And you see this type of thing. And just like this is a punishment. And also you see women also do that. But then, when we just went into mediation, some of them tough, some have to involve, embassies. It's not that you have all the answers. Mediation can also be very long, it can take really months and years, even as you resolve this one, another issue wasn't, not that it wasn't anticipated, but maybe in terms of priority, you just want to get the parties, to see that something is possible, an agreement can be reached. And then you may prioritize and you finish this. There may be also other issues that will arise from there. We've also learned, about within certain cultures, you can run away from community mediation that involves not just the parties, but also communities. And those can also be tough ones. And you have to prepare, not just in your opening statement, you have to prepare, to have this joint discussion and to begin to have different caucuses. At times, you invite this group, they finish, you go, sometimes it's back and forth and you make progress, you regress again, but patience is very, very important in the negotiation. And once the parties, because living litigation is not easy, it takes also several years, and it takes a lot out of us. It takes with several adjournments, and it takes also even when criminal matters are involved, and arrest and intimidation that goes with the kind of security system we have in some parts of Africa. It means that we need to have this going through mediation and settlement and facilitating, transformation of this type of conflict, especially interfamilial conflict, so that it will be resolved amicably. Of course, different benefits, and we know, and disadvantages, but I think what we might have to, think deeply about is, even for lawyers, for young lawyers, some are getting worried. Is there really fear that mediation, which is not like arbitration where you earn the big money, and then of course the resolution is binding, and mediation is not, then is there fear even for lawyers that of course this and then when you talk of pro bono, even with the legal aid, and where the Legal Aid Act provide, we all know that the amount being paid is small. Even for us having pro bono lawyers who are also part of providing legal aid, as pro bono lawyers for WACO, Women's Aid Collective, that we don't also pay, we cannot afford to pay commercial rate, obviously. And then we support to pay a particular, even transport, with the cost of transport these days. If lawyers used to take 5,000 to 4,000 today, for example, in Naira value, what I think most pro bono lawyers will also want even 20K, for transportation. But then also the fear, I think that fear should be the fear that people are taking away jobs of lawyers. It's not in competition. I think once we understand that this is part of our expected roles, and we do have roles to play, and we must make sure that those who are marginalized, those who lack access to justice, indeed get access to justice. And mediation should be something that even associations of lawyers should look into, like we have in IBA. So as we continue this discussion, I think building skills, targeting attitudinal shifting attitudes around this, because it's really important. Some also have very big stereotypes, very judgmental, and you can't be that judgmental. If you're mediating, it has to be, decision. Their decision, you're just a facilitator to enable them arrive at their own decision. You're not supplanting yours. And in some environments, especially in Africa, people can be highly opinionated, and then they already have a role for men. And we do have it even as challenges with some of lawyers and cases we handle. Some will come and say, oh, don't you know you're a woman? All of a sudden, they forget all of the gender sensitive languages or the training they've received in terms of gender justice. And then, because they've internalized some of these prejudices and sex stereotypes, they wouldn't know, when they are just enacting it, even when they are mediating conflict. And that could be very dangerous, especially if you're looking at family matter. Who is the mediator? What is the mediator's perspectives and worldview? It can be important. And I think in training of mediators these days, the issue of gender will really count, and inclusion, and then also being gender sensitive, knowing the language to use is very essential, because sometimes you find women be at the oh, don't you know you have to accept this? Don't you know you're this? Don't you know? So they just keep telling that until you feel like, it's out of place if you don't exactly do what they want. And in community conflict, you can see some people flare up if you're mediating and say, but that's the place of woman. That is the role of this. We cannot change that. And you have to still bring that. If you're mediating land matters and trying to get a woman access to farmlands, for example. And they said, oh, look, we have a Supreme Court judgment, and these are where cases already, who said that really made it clear that you should not discriminate against women when it comes to inheritance and succession. And if you put that and say, so if you decide to go to court and you don't achieve that, then this is also what you'll get at the end. So, but through this mediation, yes, you may say half a loaf of bread may be better than none. Okay, you may take this for now, because by the time they go through the whole gamut of litigation, the value of everything may just dramatically change. But importantly, if they are battling poverty, and then extreme poverty that are setting already, or children out of school, they may need some of this access to means of production in order to survive. So one also have to be able to put all of this in perspective and advise parties involved accordingly. I mean, I have to stop because I could go on and on. I'm running away from even, dealing with case studies and difficult cases because I've seen a lot. And then, but thank you. I'll stop here. If there are questions at the end of the day, I'll be able to respond to that. But thank you so much for the opportunity. Thank you.
Thank you very much, Professor Zilo. May I remind you that the event is being hosted by ICMC.
ICMC?
Because you kept mentioning IBA because you associate me with IBA.
It's true. I'm so sorry. It's ICMC, and ICMC is doing a wonderful work.
It's not IBA. Yeah. Yes, you spoke with
I am so sorry.
in the same panel with Mary last year in our virtual event, Access to Justice and Legal Aid Committee virtual event in the IBA last year.
So that got me confused.
Yes. So thank you for speaking for ICMC.
Okay.
And thank you for highlighting the hindrances to justice, particularly here in Nigeria that we are in. You talked about the culture, the religion. You also talked about the attitude of lawyers. You mentioned that skills need to be built to be able to practice mediation effectively, and there should be attitudinal shift on the part of lawyers, and indeed, not just the lawyers, the parties themselves, to accept that mediation have come to stay and that it is an effective way of resolving disputes. Most importantly, you reminded all of us that the major ultimate purpose of law is to assess justice. And even for lawyers, they should have it behind their mind at all times. You also highlighted the beauty of mediation, the fact that parties walk away as friends. It's very important. The adversarial nature of litigation naturally affects the relationship between the parties. I want to thank you very much, Professor Zilo, for being there at all times. I call on you and you answer. So thank you very much.
Thank you.
Dr. Abelusi, over to you.
Okay. So now we have the president, immediate past president of the ICMC, Dr. Agada Elachi, SAN. He will be talking to us on how the ICMC has intervened in providing solutions to these issues we have raised today, access to justice through mediation. ICMC has a very novel solution which has been advertised, used, and he will be giving us a whole lowdown of this. So without much ado, I will invite Dr. Agada Elachi, SAN, fellow of the Institute, to please make his presentation on our pro bono efforts. Thank you, sir.
Thank you, Dr. Abelusi. Thank you, distinguished co-panelists, convener, and distinguished ladies and gentlemen. I'm sorry I joined late. I had another engagement, and Dr. Chikwendu is aware, and she excused me. So I will quickly make my brief interventions. I'll start by saying that as an institute, ICMC has done the fact that we're the Institute of Chartered Mediators and Conciliators and the foremost mediation body in Nigeria is a testament to our contribution to access to justice. Prior to the enthronement of mediation and the practices of mediation by ICMC, either by virtue of the trainings that we have organized, certifications for members, outreaches and all that, there was really nothing going on with regards to mediation in Nigeria. It's also interesting to note that ICMC has over the years exported mediation practice to many other West African countries, And many of our colleagues have collaborated with the ECOWAS and a host of other organizations to provide training and knowledge sharing opportunities with colleagues from other aspects of Africa. But to narrow it down to the issue of access to justice as it relates to pro bono work, let me say that one of the ways that ICMC has done this is to collaborate extensively with most of the court-connected ADR centers in Nigeria. So in that partnership, ICMC has put at the disposal of the court-connected ADR centers body of membership, and our membership as of today is in the range of about 15,000. Well, as at the time I left office, it was about 15,000. I do not know what it is today. I know that only recently, I think Mr. President and the executive inducted another batch of members into the institute. So the number is growing on a daily basis. But we have collaborated, so you find our members providing mediation services at multi-door courthouses in Akwa Ibom, in Cross River, in Lagos, in Abuja, and a host of other places, Kano particularly. We are there. What is instructive to note is that ICMC has provided leadership in the setting up most of these multi-door courthouses, and at most of these multi-door courthouses, most of the work that we have done have been done free. I reference particularly the work that has been done in Ogun State, where a collaboration between ICMC and Ogun State Judiciary has led to the setting up of 5 multi-door courthouses in Ogun State. Of course, this initiative was championed by our own very own Segun Ogunyonwo under the leadership initially of Dr. Brown Ogbefun, and then it was carried on during the tenure of my brother Emeka Obegodo SAN. And then, of course, in my time as president, we also pushed that partnership forward. But my personal and my favorite aspect with regards to pro bono work, promotion of pro bono work and strengthening of access of justice, which ICMC has done, is regards to the volunteer mediator scheme. VMS, we called it, we christened it, which was launched in my first year in office as president of the Institute. And I'm proud to say that Dr. Rosemary Chikwendu, as chair of Abuja branch, was available, leading Abuja branch to partner with the national executive at that time to launch that scheme. The way the volunteer mediator scheme works is ICMC looked at the fact that there was need to provide opportunity for our members to acquire experience. So whilst we train and certify and accredit members, a major challenge that a lot of our members faced at the point was will they find opportunity to undertake work, actual mediation work, particularly how do they conduct that mediation in the work, opportunity to also provide some sort of mentorship, supervision, and ensuring that the best global standards are. So we were able to achieve this, and the scheme work was we would put together members who had been trained, accredited, and certified were invited to volunteer to serve on the volunteer mediator scheme. And then when they volunteered, the list was put together. And then after that was compiled, we put them through some sort of screening process, some verification and assessment process to ensure that everyone who was to participate in the scheme, the scheme is ongoing, so everyone who is to participate in the scheme is veritably qualified and has the experience, or at least the requisite knowledge to move the process forward. We recognize the fact that some of our members, as at the time they had been inducted, had not had any opportunity at undertaking any practical mediation session. So what they had was at best theoretical knowledge and some of the knowledge that they gained from the role play sessions. So what we did was to put an experienced mediator, for instance, say like Dr. Rosemary Chikwendu, on a panel, leading the panel with someone else who probably has had one or two practical mediation experience, and a new inductee, someone who has no experience whatsoever. So we had set up panels of maximum of three mediators. And then, of course, we had several panels set up. And then we went on a campaign, an advocacy, to use the proper word, an advocacy that encouraged members of the public, particularly in certain sectors in Abuja, where our focus, we had a great focus on the markets and commercial disputes among traders and all that. And in some cases, we took the volunteer mediator scheme right to their doorstep, where a body of mediators, panel of mediators, each panel consisting of three mediators, will then sit and assist disputing parties in resolving their issues. It was a huge success, and it continues to be a huge success in two folds. One, it provided needed access to justice for members of the public who ordinarily would not be able to afford the services of a certified mediator, ordinarily would not be able to even approach or move to the confines or to the location of a multi-door courthouse to seek intervention in their matter. It also provided our members, especially those who had no practical mediation training experience, to now acquire the real-time mediation experience, dealing with the knotty issues, emotions, helping parties identify their interests, needs, concerns, and a host of other things which host of other strategies which help to build their confidence. And the way the scheme works is that by the time a person has sat along on that panel dealing with two or three matters, the chairperson of the panel will be removed from that particular panel, and a new panel will be set up where that chairperson will then have less experienced mediators working with him or her. Then the co-mediator, the second person with minimal experience, will then rise to become chair of the panel. The person who had just been trained, who now has experience dealing with two or three practical mediation sessions, will then become the co-mediator or number two mediator, and then we'll bring on board a newly trained mediator who then has the opportunity of, again, developing those practical experience and skills. So all of these, this was the strategy we developed at that time. And we have launched the VMS scheme across several branches of the Institute. I'm sure that at the introductory point, the current president of the Institute, my worthy successor, Godwin Amoka, must have informed you that we have branches in almost all the states of the Federation. So, and in some cases, states, we have two branches. So we've launched the VMS scheme in most of these places. So that has veritably helped itself in the advancement of access to justice. And of course, members of the public are able to take advantage of this. And of course, ICMC is able to give its own back to the society in terms of corporate social responsibility. So this is what ICMC has tried to do in promoting access to justice. We continue to work on this. We're constantly working hard to fine-tune this. And as a final point, I would say that one of the things that we are now, which we have, well, I was helping to develop before I left office, and I'll continue to work with the executive to see that we can bring to fruition, is something called the verbal judo, which is a new concept around this part of the world, but it's not completely new. When I led the executive committee at the time to pay a courtesy call on the Inspector General of Police, one of the things we advocated and we offered them the opportunity to provide training and knowledge sharing on his verbal judo. And verbal judo is a tactic for de-escalating conflict, especially social and communal conflict. And that's another way that ICMC hopes going forward in the near future to be able to again impact positively the issue of access to justice. Because as we know, with access to justice, not everyone who has an issue sometimes will even have the opportunity of coming forward to present it. So sometimes we, the practitioners, we, the mediators, we, the dispute resolution practitioners, must take our intervention strategies to them. ICMC has been leading in this regard, and we will continue to lead in that regard. I thank you, Dr. Rosemary Chikwende, for inviting me for this intervention, and that will be my humble contribution with regards to this very topical issue. Thank you.
Thank you very much, Dr. Agada-Ilachi, for the insightful presentation. Most importantly, you forgot to mention that we partnered with GIZ to be able to, because just like lawyers, as Professor Ezelo mentioned, just like lawyers that if they are offering pro bono services, you at least give them transportation money. Just like lawyers, mediators also need transportation money, you know, for the practice of our pro bono services. We've been partnering with GIZ, and we are open to more partnerships. I thought you mentioned that because we need it. We are open to more partnerships, and that will enable us do more. So I thank you, and I had expected Dr. Belusi. Dr. Belusi.
Thank you, Dr. Chikwu. I'm happy you filled in that gap. Forgive me. I was trying to keep within the 10 minutes time frame that I was given. Thank you. Okay.
All right. So, you're muted, but I think it's time for us to put the floor open to participants to put their
Okay, I
questions.
hear I was muted. I muted it so that you can speak.
Yes. So I think it's question time now.
Okay.
So
do we take questions from the chats or?
Yeah, from the chats.
Okay.
We have, if anybody you want to unmute, any of our seniors who are here, we can allow them to make their interventions. Joshua will do that.
We'll need to take the questions so that Mary can go to bed.
Yes. Mary, there's a question earlier for you. It says the administration of justice does not produce outcomes that reflect justice. How does mediation fill this gap?
Okay, I think this is a really important question about what justice is, and I've grappled with this for a long time. And I referred to the quote from our Chief Justice that our system of law recognised that the administration of justice does not prescribe any flexible or invariable standard of justice so long as a minimum standard of procedural fairness is observed in the process. So he says that. I say, but you need an ethical base, obviously, and he spoke about that in a different speech. But what are we talking about as far as the fairness or what justice is? Is that for the parties to have full autonomy to be able to make their decisions and have full information and knowledge about what it is that they want to consider to make a decision? And I think we need to empower the parties in the mediation process to identify that, but also to have assistance if required. So legal assistance to work that through. And that's not always possible, particularly in areas where there are, vulnerable people. So how do we look at that? What do we say is an appropriate standard of justice or appropriate outcomes? And I think that's a really vexed issue. I think what you can do, certainly when I have dealt with people who do not have resources, is to ask them what they need, to talk to them about how they empower themselves, to talk to them about what is necessary. And if they do need a risk analysis of what will happen if the matter were to go further to trial, so they can actually begin to weigh up what's achievable in the mediation or what their future looks like as compared to what it is in the mediation process, We have to have those conversations. So what one perceives as justice for one may be different for another. But as lawyers, what do we say is an appropriate ethical standard that is applied to allow for justice and access to justice with just outcomes? And I think we can all spend hours on the jurisprudence of this. But in mediation, I think what the mediator needs to do is to work with the parties to get them to a stage where they're fully informed or sufficiently informed to be able to make decisions for themselves. And that does take into account cultural sensitivities. It takes into account their needs, goals, and expectations. And underpinning all of that, as lawyers, there is the rule of law and what is appropriate. So if I was in my jurisdiction, one of the areas that becomes really focused on this particular issue is if, for example, in the environmental area, there is an agreement. What about the public interest? Is it okay that people agree to pollute, or does it have to go to court for an oversight? What is it that we say is sufficient in sufficient circumstances? And I think we have not finished that journey. And I think that asking the questions and having the narrative about what that looks like is important. I noticed that there was a question that talked about perfect justice. I'm not sure that there is a thing called perfect justice, but I think that we need to look at the conceptual frameworks in which we work within and to assist parties about what that fairness and justice looks like. And I remember a terrible case that I heard about, and this is just, you know, the talk between people many years ago. It happened, I think, in the early 90s, where there was a family law dispute where there was violence, and some mediator in another jurisdiction in Australia, not mine, allowed the parties to come to an agreement where the woman could be beaten, but only where it would not be seen, so she could wear clothing that would cover the injuries. Now, how outrageous is that? How outrageous. And, you know, one has to sit back, I think, and we need to begin to understand what the parameters of ethics are in this area. And that's why at the Law Council, we prepared 3 sets of ethical guidelines, one for mediators, one for lawyers, and one for parties. Now, I cannot say that that anecdote from many years ago is something that was accurate, but I think it is a very good example to say, well, the parties could come to something which is absolutely illegal. What is the role of the mediator in relation to that outcome? And what is the idea of justice? And I think if we take the examples that are at the extreme end, they help us inform ourselves about what those levels are. So I'll leave that for people to consider. I think I cannot give you a definitive answer on this. It's a work in progress.
Thank you very much. Thank you very much, Mary. We'll definitely have a lot to think about on that point. Olufunso, you can unmute and speak.
Good evening, everyone. Thank you for the insightful presentation. My question is, how can members register for the volunteer scheme, either in Abuja or Lagos? Can you hear me?
Yeah, okay. Madam Olufunso, the volunteer mediator scheme is open to all members of the institute. Where are you based? If you're based in Abuja, then, yes, please join the Abuja branch of the institute. And as soon as you join, they have a register for volunteer mediators and they will incorporate you immediately into the process.
Okay, sir.
Yes.
Am I to join online?
Dr. Chikwende is an person. She will guide you.
Okay. All right, yes. Sir. Okay, sir. Thank you very much.
Please, for those that have questions and will want to get a link or any of the presentations, can you drop your email online in the chats forum, please? Thank you. Dr. Abelusi, any other question? Because I can see some of our fellows online.
There's a hand, Reverend Michael.
Reverend Michael. Okay.
Yeah. Thank you and good afternoon. Thanks for this webinar. I'm a member of Nigerian Justice of the Peace, which we go on for criminal justice. Well, I'm now asking in terms of mediation, how do we partner with state judiciary to carry on our activities in terms of access to justice? Thank you.
I'm sure Professor Zilo is still online. Prof.
Well, before Prof comes on, let me just
take
a go at that. Reverend, it's very straightforward. Again, the Institute has a robust framework through which it partners with the various ministries of justice and the various judiciaries. So if you can liaise with the Institute, I am sure that whatever partnership structure you would like to push forward can be dealt with. Our focus at the Institute at all times is to enhance the capacity of members of the public to get justice. And since your work borders on the issues of criminal justice, ICMC has collaborated. We now advancing discussions on things like restorative justice. We have had some collaboration with the Federal High Court in that regard. But as I used to say when I was president, and I want to restate again, the functionality or otherwise of a member is usually best achieved through the branch network. It's easier to deal with the branch closest to you or which you belong to than to always try to liaise with Abuja for effective collaboration. So that's my feedback.
Thank you, sir. Barakat.
Yes, good evening, Sir Mas. I want to appreciate the organizers and our amiable speakers for that insightful presentation. So mine is that I want to know how we can penetrate Ilorin judiciary, because given the training we had on mediation, I believe it is incumbent on every state to explore mediation. But it seems as if the feedback I'm always receive is somehow discouraging. So, and I want to ask our elders, how do we penetrate in order to establish a multi-corridor house in Ilorin judiciary? Thank you, sir.
Dr. Agada?
Okay, well, Ilorin, Kwara State hasn't been an easy nut to crack. We have tried our best as an institute to promote access, to promote the knowledge in Kwara State. We require further collaboration. So, Madam Barakat, what I think you can do for us is identify for us key stakeholders with which the Institute can engage and hopefully convince to appreciate the benefit of bringing, establishing a multi-door courthouse or a court-connected ADR center. It takes a lot of, conviction by the head of court, in this case will be the Chief Judge of Kwara State, to appreciate for an establishment of such nature. What we have done in some locations, and we can reference Ogun and a few other places, is that you need to demonstrate to the leadership of the judiciary in Kwara State the benefits of the multi-door courthouse, the benefit of a court-connected ADR center, the benefit of what it does in terms of promoting access to justice, what it does in terms of decongestion of the docket of judges, what it does in terms of promoting harmony and accommodation, tolerance, and all that within the entire societal framework. So these are not things that can be dealt with extensively here at such a forum, but I'm sure that if you contact Mr. President and the registry, they will give you some of the templates of proposals that we've sent forward before, and I'm sure that the leadership will be happy to work with you and a few others who are based in Kwara to drive that process forward.
Thank you very much, Dr. Agada. Before we continue, I want to recognize some of our fellows that are online. We have one of our vice presidents, Mrs. Chinyere Onyemenam. We have Honorable Justice Florence Fibrisima. We have the Registrar of the Institute, Aisha Ablahi. We have the Chairman of National Industrial Arbitration Panel, Mrs. Pamela Zinge. We also have the Vice Chair of the National Industrial Arbitration Panel, Olivia Neko-Fordile. This one that we have both of you, I hope you people are going to give us people to train this year. Please, I would like to invite each and every one of you to make a 1-minute intervention, starting with Mrs. Chinyere Onyemenam. Chinyere, can you unmute yourself? Okay, I just saw that we also have Ambassador Shegu Ogunyonwo online. Just seeing him. We also have the chair of Abuja branch of ICMC, ARA. Chinyere, are you still online? Okay. My Lord Justice Florence, are you still online? Okay, they seem to have dropped out.
Yes, I'm here, but
okay. Can you in here. 1 minute give us your contribution?
Well, my contribution will first and foremost be to say well done to ICMC for going global. Let me put it that way.
Yeah.
I think it's a good thing for us that we're going global to take on the message of mediation to the world, and at least also to showcase our intervention so far in Nigeria. And I must say that just listening to some of the speakers, because I also came in a bit late, it's the same thing we've all been saying, that access to justice for the vulnerable in our society, for the larger portion of the society, can only be better achieved when we begin to infuse mediation in every facet of our justice system. And from my personal experience over the years of being a practitioner, I know that the interventions are always very, useful. They are always very, very, impactful also for those who get the benefits of mediation services. So it's a good topic that we have had to listen to. Listening to Professor Joy, you can see the extent to which women, groups have been able to drive the gender, side of the issues of mediation, in the practice. So I encourage us to continue to spread the message that we can achieve access to justice in our kind of society if we infuse mediation in our justice system. And let me also add that the multi-door courthouses are gradually gaining ground. There's no doubt that we do have some challenges with the practice, but like everything good that starts, you have challenges, but I don't think we should be deterred. Let's look at those challenges and look at how we can, turn them around to positive things, and then, we can overcome them and ensure that we can continue to practice mediation in Nigeria. Thank you, Rose, for allowing me speak. I better stop.
Thank you very much. You better stop indeed. What gods do I have to tell a High Court judge? My hands were bound.
Sorry,
Thank
I
you very
forgot that
much
I
for
wasn't
that
doing a paper.
intervention. So
Thank you.
can we hear from please 1 minute so that we'll be able to get the speakers to give their final thoughts. Can we have the registrar of the Institute, Aisha Ado-Abdullahi?
Thank you so much, Dr. Rosemary. Thank you, everybody. All I can say, especially if you are giving me a minute, is to appreciate everybody. I guess in a minute, I can only say thank you to all those who spoke, contributed, and this is a really wonderful initiative. I believe that it's a step in the right direction. The discussion, the talk on increasing or improving access to justice for everybody cannot be overdone. We cannot say that we've spoken too much about this. And now that we have taken it a notch higher, partnering with international organizations, especially far and wide, such as the UN, the IBA, with my colleagues, Mary, Sean, I feel we are moving in the right direction. So thank you very much, everybody. And we will continue doing the good work together. We can make the change that is necessary to
Mary
get
is waving
the world
manually.
where we want it to be. Thank you.
Mary is being analog and waving manually.
Hi, Mary. Hi, Sean. Hi, everybody. Thank you very much, my colleagues in ICMC. So we'll keep doing it. Thank you.
Thank you very much, Aisha. May I call on Ambassador Segun Ogunyonwo, if he's still online?
Thank you.
1 minute.
I appreciate the privilege. Great presentations. I've learned a lot today, a great lot. Thank you. 3 things I will say very quickly. First, Chief Justice Warenberger said that the notion that people want black-robed judges, well-dressed lawyers, and paneled courtrooms as the places for correct. People with problems, like people with pain, want relief, want it as quickly and expensively as possible. We're excited that we're talking about access to justice. Most of the courthouses, multi-door courthouses, have as their vision the fact that access to justice means more than access to the courts. Providing access to justice means providing timely, cost-effective, and user-friendly access to justice. This topic coming up today, I want to thank the leadership of ICMC and all those who have partnered to make us now start talking at the global level. There's a question I posted on the chat while talking about access to justice. Where does the MBA come in? They have fixed the charges of lawyers in different states. It's good news for mediation, but I think it's good news for access to justice. How would you fix it to have people who are vulnerable, women and children? For this opportunity, thank you once again. I appreciate you. Thank you.
Thank you very much, Ambassador Segun, for keeping to the time. Can we have Mrs. Pamela Azenge? chairman of the National Industrial Arbitration Panel and a fellow of ICMC. Mrs. Azinge, can you unmute yourself? Okay, I'm not sure she's still with us. Can I have the Vice Chair of the National Industrial Arbitration Panel, fellow of ICMC, NEC Olivia Ofodile, speak? 1 minute intervention, please. Okay, maybe they conspired to leave before we ask them to do something for us. Okay, I can see before me the chair of ICMC Abuja branch, also a fellow of the institute. My chair, I know you're in a car. Unmute yourself.
Thank you very much, ma'am. Madam Chair Emeritus. Well, I would say thank you very much for this. Glad that you participate in this. We had a lot of wonderful presentations, and the entire session as a whole has been wonderful. For me, it's an experience that is worth the while. I only say thank you very much for a wonderful outing. Thank you to the Institute, and thank you to all the organizers of this program. I think it's been a worthy outing, and I pray that we'll have more of this, and that we'll be able to achieve, more access to justice in our society. Thank you very much for the opportunity. Thank you, ma'am.
Thank you very much, my chair. Please, can everyone drop their email addresses in the chat? I'm not sure we'll be able to take more people because I want to give the speakers time to give their last thoughts on the session and on the topic, starting from the keynote speaker. Mary, are you still available?
Yeah. Yes, just trying to get, yes.
Please, your final thoughts in 1 minute.
Thank you very much for including me in this presentation. I really appreciate it. And I want to wish you all well in your journey in ADR, because that's what it is. And I think that you have done, when you look across jurisdictions around the world, an enormous amount in implementing mediation and conciliation, but particularly mediation already. And I think that what we are doing into the future is looking at the challenges that we will have in the 21st century. And I think you've begun to identify many of them, including the access to justice issue. But I think we have a lot to confront as far as identifying value-laden disputes. And I've been talking quite a lot about this in recent times because I think that our people are beginning to say they want a voice on many issues. And not everyone will have an opportunity to access the courts. And we need to, for social adhesion, for democracy, for assisting access to justice for all, is to begin to think about how we are going to engage in these challenges in the future. And the consensual processes of ADR, particularly mediation, give that opportunity. And I think that having heard all of you on a number of occasions, I think you are so well placed to be leaders in this field and well placed to assist your people in your jurisdiction access to justice. I've heard also about the many challenges you have in the family law and community areas. And I think also that you will expand your reach. I can hear and see all the chats that are coming through. And all I can do is to say I inspire you to continue. And if you need us at the IBA or anywhere else, we're here. But I'm sure you can do a lot. You already have. And I take my hat off to you. And thank you very much for including me here.
Thank you very much, Mary, and thank you for being there always, always. The notice is never too short. Thank you very much.
A pleasure.
Mr. Sean, if you are still available.
I was on mute, sorry.
Okay.
Thank you
In
very much.
1 minute, please.
1 minute,
yes.
now. Thank you very much to yourself, Dr. Agbelusi, the other esteemed delegates and guests and colleagues, and the ICMC for inviting me here. It was a great honor to share some of my experiences with you and to hear of what I consider to be quite impressive progress that you are making in your region and also with the ICMC. I think to add to what Mary has said, and which was in the back of my mind, one of the questions was how do we move forward? I think a key component in progress is the practitioners' awareness. If the practitioners are aware, and if the practitioners who are on the front line are able and genuinely believe, as for example all of us here do, that there is substantial merit in referring matters to mediation, then we can approach the Chief Justices, who in turn can approach the various ministers, and we can continue to push. I had mentioned, and we had all mentioned, pro bono services. Again, in Jamaica, we have the legal aid lawyers, pro bono lawyers there. We have the Dispute Resolution Foundation offering free or extremely reduced fee mediations, which everyone has access to, not only through referral from the courts. So those are ways, and I think, again, I'm just going to reiterate that us on the front line as the practitioners are really the starting point, the match, the ignition point of and momentum, the catalyst to move this forward. Yeah. So once again, thanks to everyone. Good luck on your journey, and we're all in this together. It's not perfect anywhere at all. Justice, as Mary indicated, is subjective. Especially with mediation, everybody has a different story. As I said, I try to illustrate that, but mediation can allow people to vent, to express themselves, to be heard, to be appreciated. And that, in the end, I think is what the substance of justice is for many people, yeah, to be appreciated, to be respected. So my thoughts. Thank you again very much, and good luck.
Okay, call on Professor Izilu, I think has left us. So call on Dr. Agada to give his own final thoughts.
I'm not sure if I broke off there or if I lost my...
No, there was a problem from the source. Professor Zila, are you still available?
No, she's left. So it's
okay.
Dr. Agada.
What about Dr. Agada Elachi?
Okay, maybe he's left also.
Mr. President, are you still available? They actually will think that the meeting ended. Mr. President, are you still available?
I think he also left.
He hasn't left.
He left already. We can do the vote of thanks.
Okay. So I just want to, you are giving the vote of thanks. I just want to share my final thoughts. Just to thank the president for giving me the honor of registering and organizing this session. I don't take it for granted. When the idea of registering ICMC for a CSW events came up in December, it started like a joke, but here we are now. And I just want to say thank you for giving me the opportunity to do this. I'll hand over to Dr. Abelusi to give the vote of thanks.
Thank you very much, Dr. Chukwendu. On behalf of the organizing committee and myself and Dr. Rosemary Chukwendu, I want to thank all of you for your hearty participation and valuable contributions to today's webinar on the use of mediation as an access to justice. Our distinguished panelists have shared profound insights, shedding light on the pivotal role of mediation across jurisdictions in ensuring equitable access to justice for all. The questions and your interventions have enriched our discussion and have also enhanced our collective understanding of this critical subject. I want to thank all the technical support team, the secretariat of ICMC, the president and the EXCO for their unwavering support in making this event a success. And as we conclude today's session, I want us all to carry forward the spirit of collaboration and innovation in advancing the cause of accessible justice through mediation. Let's all make efforts, especially as ICMC members, to join the VMS scheme and offer pro bono mediation. And in our own little catchment area, let us volunteer to be peace builders and to share reconciliation within the communities using the skills that we've learned from ICMC. Once again, I wish you all a lovely evening, afternoon, morning, wherever you are. And thank you so much for attending again.
Thank you very much, Dr. Abelusi. Thank you, everyone, particularly the technical committee. Thank you, Mary. Thank you, Sean. Thank you.
Let me add my voice to that. Thank you.
Yes. Thank you, Joshua. Thank you, Sean.
Thank you, Rosemary. Thank you, Dr. Abelusi. Thank you, everybody. Fantastic. And I wish you all the best.
Thank you, Joshua, for all the trouble and for making sure that we didn't have any problem.
For such a thought-provoking webinar.
Thank you. And God bless you all.
Thank you, Excellencies. I appreciate you.
Thank you very much.
Thank you, Your Excellencies.
Thank you so much.
Really informative. I appreciate it.
Thank everybody for this session, for this wonderful
Thank you all.
Thank you very much. Thank you.
Thank you all.